Good morning. I wanted to take a little time this morning just to talk through what we need to do as far as assisting the Smith family with the estate of John Smith. So let me share my screen so we can get started. Okay, so I'll just kind of give you an overview of what I intend to discuss today. I think that we start with a review of the family structure and responsibilities. Let's talk through the probate and non-probate assumptions. I've got some key items that I think we need to dig deeper into. Let's talk about principal and income considerations for those two trusts, and then we can move on to next steps. So let's first start with that family structure and responsibility. So we know that Teresa Smith is the surviving spouse of John Smith, and she is the named income beneficiary of the testamentary trust that will be created through the will. We have Julie, Jill, and Sam as their children. They have no grandchildren at this point in time. I think it's important to note that Jill and Julie are the co-personal representatives of John's estate, and they are the co-trustees of both the living trust and the testamentary trust. Now, Sam was named as the acting power of attorney for his father and is the surviving owner of a checking account that was owned jointly with his father. So as we look at the property assumptions as far as what might be probate, what might be non-probate property, let's start on the non-probate side. We have the home, the family home that was jointly owned with Teresa and John, and we just need to verify that that was owned in a joint tenancy agreement. I'm assuming it was. We also have a checking account that was owned jointly between John and Teresa. Same thing there. Was it owned jointly, or was there a transfer on death in place? We have John's retirement account, which he named Teresa as a sole beneficiary, so that will pay outright to Teresa. We have that checking account that I mentioned that was owned as a joint tenant with rights of survivorship with Sam and John, so Sam is the surviving owner of that. We have an Edward Jones stock portfolio in which the living trust is the owner. We have a life insurance policy that pays out to Jill, Julie, and Sam, so they will be paid outright outside of probate. And then, as I mentioned, we have that living trust in place. Now, on the probate side, we've identified 3 rental properties that are owned in John's name. So those will most likely pass through probate and then be transferred into the testamentary trust. Then any additional assets that were not included in that living trust will be included as part of the probate property. And that will include anything, including personal property. So let's talk about items that I think we need to address a little bit closer. First of all, let's talk about the estate administration. As I mentioned, Jill and Julie are the co-personal representatives of John's estate. They've got a lot on their plate as they're going to need to complete a full inventory of all the assets held outside of that existing trust. And they're going to need to determine if John had any outstanding liabilities that need to be addressed. They'll also need to obtain date of death valuations and ensure that the estate property is securely custodied and, if needed, insured. If the estate goes through probate, they will obtain the probate court's authorization to transfer those assets into the testamentary trust via John's will. Julie and Jill will also be responsible to ensure that John's final personal tax return is filed, and if needed, a Form 706 estate return will need to be filed. From there, let's take a closer look at John's will and testamentary trust provisions. As I mentioned here, Jill and Julie are the named co-trustees of this testamentary trust. Teresa is the income beneficiary of this trust, and the 3 children are the remaining principal beneficiaries of this trust. So we need to look at what assets will be held in this trust as principal, in addition to those rental properties. And will any of the other assets be income producing? We'll also want to look at any significant details in the will or the testamentary trust provisions that we might need to be mindful of. Now, we'll also need to look at that existing, now irrevocable living trust. Again, Jill and Julie are the co-trustees. We know that the trust holds John's Edward Jones stock portfolios, and I'm curious to know what else it holds. Who are the named current beneficiaries of this trust? Who are the future beneficiaries? I'm really curious to know if Teresa is the current income beneficiary of this trust as well. Again, we'll need to look at if there are any significant trust provisions that we need to be aware of. Finally, I want to determine where Sam falls in all of this, as I think it's kind of interesting circumstances here in that he was not named as co-executor or co-trustee of either trusts, yet he was named as his father's attorney in fact and was joint owner of a checking account with his father. I'm curious to know if while John was alive, if Sam did exercise that power of attorney, and if so, did he make any significant decisions that could impact the estate? And then it would be good to know if Sam was involved in the ongoing management of the rental properties or other business ventures with his father. So let's talk about the principal and income considerations for those two trusts. First, we have the existing living trust, and we know that we have an Edward Jones stock portfolio held in this trust that would be principal. I would assume the portfolio holds dividend paying assets, so those dividends would be paying income to the trust. So we also need to know what other principal assets are held in this trust. It could be cash, it could be other investment accounts, maybe real estate holdings. I'm wondering if there's additional rental properties held within this trust, or maybe an LLC or another business entity that's owned by the trust. Finally, we need to know if there's any liabilities attached to this trust, such as promissory notes. On the testamentary trust side, we know that those 3 rental properties will be transferred as principal holdings to this trust, and we can assume that those properties are occupied and producing consistent income. But we obviously would want to verify that. We should be able to use the estate inventory to ascertain what other significant assets will transfer into this trust as principal and determine if any of those assets could be income producing. So let's talk about next steps as I see it. First, we think we need to complete the discovery that we outlined in this meeting to answer outstanding questions that we have identified so we can get a holistic picture of this estate. Then I think we can review further and see if there's other concerns that we have not yet delved into. From there, I think we need to schedule a meeting with Teresa and the children to get everybody on the same page. Hopefully, this meeting will be perceived as a positive step that will encourage everyone to feel comfortable in voicing any of their concerns with full transparency. I'm thinking it would be beneficial if we take the step to talk to each of these individuals and give them the intent of these meetings as we call to schedule the meetings. I think if they know the intent going in, they'll be better able to prepare, and we might even be able to help them prepare for those meetings. Some of the things that I think that we need to put on the agenda for discussion in that family meeting would be first and foremost, how is Teresa doing? And is there anything that we or family members can do now or in the future to help her? I think that we then need to do a quick overview of the discussion points that we discussed today regarding John's estate administration, the formation of the testamentary trust, and the evidence of that living will, living trust. In this discussion, I want to find out if Jill and Julie are concerned about the responsibilities that are falling on their shoulders. I know they're both busy individuals, and this is a lot. I'm wondering if they feel comfortable in handling this level of responsibility. If they are feeling overwhelmed, I think that we could maybe suggest that they consider engaging us as successor trustee of the 2 trusts and potentially assist them with the estate administration as well. And I think that this might come out organically as this conversation progresses, but if it doesn't, I think that we need to gauge how the family members are feeling about everything. What are their concerns? Do we need to delicately kind of flush out what distrust or animosity might exist amongst the siblings? I'm just thinking if we address it now, we can possibly smooth that pathway and avoid litigation potential down the road. Finally, I think that we can help them by providing resources. And what I mean by this is I think that we should proactively put together a proposal regarding services that we can provide, what our trustee fees would be, and how they would go about naming Gateway Trust as the successor trustee. If they express interest in this, we can certainly walk through that proposal. I'm assuming that they already have a tax professional in place that they work with, but if they don't, we can certainly give them some resources. If they do have a professional in place, I think it would be helpful to have that contact information so that we can work with them. And as yet, we don't have an understanding of the estate value, so we don't know if it will have to go through probate. But with the threshold in South Dakota being $100,000 and those three rental properties being in the mix, I am guessing that they will have to file through probate court. So if they do need a probate attorney, we can provide them with some references there as well. So let's get to work gathering the information we need and building out our resource documentation that we want to bring to that family meeting. I will call each of the family members to discuss the family meeting with them and coordinate a date and time that works best for all, hopefully sooner rather than later. Thanks for your time today.